Imagine waking up to find someone breaking onto your property. You grab a weapon to defend yourself, but here's the problem. Use the wrong kind of force and you could be the one in handcuffs. I'm Rick Fletcher, a Florida criminal defense lawyer. I've defended people in cases where self-defense, stand your ground, and defense of property were at the center. I know how prosecutors analyze these cases, and I know how the courts draw the line. Today, I'm going to explain Florida's Castle Doctrine, the presumption of fear in Florida Statute 776.013 in three important cases: the Falco case, Burns case, and the Paese case. You'll learn exactly what the law allows when protecting your home and property and what crosses the line. Florida law strongly protects the home, but it does not give you unlimited power. Misunderstand that difference, and the same law that you thought would protect you could be used to convict you. Now, my wife and I run a criminal defense practice in St. Petersburg, Florida. We've defended clients who used force to protect themselves or their property. Some walked away with immunity, others ended up facing years in prison, and the difference often came down to whether they understood the boundaries of Florida's Castle Doctrine. Florida has some of the strongest self-defense laws in the country. The Castle Doctrine means you do not have to retreat in your own home, but there's a big distinction. The law treats deadly force and non-deadly force differently. Deadly force is reserved for preventing death, great bodily harm, or a forcible felony. Non-deadly force, though, may be used to defend property itself. So let's break it down. Florida Statute 776.013 codifies the Castle Doctrine. And here's the key language. A person is presumed to have held a reasonable fear of imminent peril of death or great bodily harm when using defensive force that is intended or likely to cause death or great bodily harm against another who unlawfully and forcibly enters or has unlawfully and forcibly entered a dwelling. This presumption of fear is powerful. If someone unlawfully breaks into your home while you're inside, the law presumes you reasonably feared for your life. That presumption makes it much harder for the state to argue you overreacted. But the presumption doesn't apply if the person has a legal right to be there, if they're removing their child, or if you're engaged in an unlawful activity yourself. So strong protection, but not unlimited. Now here's the first case, the Falco case. Falco set up a spring gun trap in his home, a .22 caliber rifle rigged to fire when someone moved through the bathroom door. A teenager broke in, entered through the bathroom, and was shot and killed by the device. But no one was home at the time. The Florida Supreme Court upheld Falco's manslaughter conviction. The court explained that the Castle Doctrine protects occupants who are present and facing imminent harm. It does not authorize deadly force devices to protect an empty house. Quote, the manslaughter statute did not violate equal protection in demanding the presence of a person to justify use of deadly force in defense of his dwelling. So the takeaway here is Falco teaches us the limit. You cannot use deadly force to protect property alone when you're not there. The Castle Doctrine is about protecting people, not setting traps for burglars. Now let's talk about the Burns case. Mr. Burns was confronting a tree cutting crew he believed had entered his yard without permission. He retrieved a firearm, displayed it openly, and began loading it in front of the workers. They claimed they were threatened, and Mr. Burns was arrested for aggravated assault. The fourth DCA reversed his conviction. The court stressed that displaying or loading a firearm without pointing or firing it is non-deadly force as a matter of law. Once the workers became trespassers, Burns was entitled to use non-deadly force to make them leave. Quote, the display of a firearm constitutes non-deadly force as a matter of law. The key takeaway here is Burns shows that Florida allows non-deadly force to defend property alone. You cannot kill to protect land or things, but you may use reasonable non-deadly force, even displaying a firearm, to ward off trespassers. Now let's talk about the Paese case out of the 4th DCA in 2024, where Paese lived in a condominium and code inspectors and staff entered her foyer without permission. She reacted by knocking a phone out of someone's hand and throwing duct tape at them. She was charged with felony battery. And in that case, the 4th DCA sided with Ms. Paese. The court ruled that stand your ground immunity applied because she used non-deadly force to prevent wrongful interference with her property. The opinion emphasized that immunity isn't just a trial defense, it prevents arrest and prosecution when justified force is used. Quote, stand your ground provides a substantive right to not be arrested, detained, charged, or prosecuted. Now, in Paese, They reinforce what they said in Burns. Florida law recognizes the right to use non-deadly force to protect property against wrongful intrusions. Even minor acts like swatting a phone or tossing an object can be protected by immunity if they're reasonable. Now, how does this work in real life? If someone forcibly breaks into your occupied home, deadly force is presumed lawful under 776.0. If your home is empty, like in Falco, deadly force traps are not justified. If someone trespasses on your property, like in Burns, you may use non-deadly force, including displaying a firearm but not pointing it at them. If someone wrongfully enters the foyer or a shared area, like in Paese, non-deadly force may be lawful, and immunity can protect you from prosecution. Now, people do make mistakes in believing that they can always use deadly force to protect property. They can't, forgetting that Castle Doctrine protections require presence inside the dwelling, assuming immunity is automatic, but in reality, it often requires a stand-your-ground hearing. Now, how do you protect yourself? Deadly force is only justified to stop imminent death, great bodily harm, or a forcible felony. For trespassers or property-only threats, limit yourself to non-deadly force. Document incidents with cameras or witnesses. Don't escalate unnecessarily. Even displaying a firearm can be powerful enough. Always call a lawyer before giving any statements to police. Florida's Castle Doctrine and defensive property laws are strong, but they do have limits. Now, if you found this video helpful, make sure to like and subscribe to our YouTube channel. Call Fletcher & Fletcher if you've been charged with a crime after defending yourself or your property. We know the law, and we know how to fight for your rights.